Okay, great. Hello, everyone. Thank you. Thanks for taking the time out to join us for some time this evening. I'll quickly do very short introductions. I don't want to obsess about us and our personalities and what we've done. Just want to get to the actual discussion. So we have my father, Dr. Bharat Nain, also the co-author of a book on arbitration. The both of us have written that together. He's an industry professional and arbitrator with about 40 years experience in various fields. We'll also be dropping the LinkedIn contacts, etc., which you can check out. We've got Jonathan Rodriguez, who's a mediator. So this is his work. He's a full-time mediator and works in mediation and around mediation. He's also available to connect with on LinkedIn, and he works in UK and India. Of course, we have Gokul. So I'm sure most of you know Gokul. Gokul's a legal educator, entrepreneur, and a mediator. And so he's going to bring in a perspective of education and ADR, alternative dispute resolution. And I'm Aditya, and I'll be playing moderator over here. All right, so I'll quickly, before we jump to the questions and the discussion, I just want to quickly set the stage. So we're here today, everyone, to discuss alternative dispute resolution or ADR. Which we can break down into many things, but we're going to talk primarily about arbitration and mediation because we've got experts in those fields here today, and these two make up a bulk of ADR. And for those of you who are not familiar with ADR, essentially when disputes arise, we tend to think of the courts and the court system, and I know that a lot of people here are law students, so that's quite natural. But the final end or the aim in when a dispute arises is to resolve the dispute, right? To solve the problem. So whether you take the court approach or whether you take another approach is an open question, right? So you can decide to litigate a matter or you can decide not to litigate a matter. So are there non-litigative options for resolving a dispute? And we want to bring those to the fore today and talk about those, specifically arbitration and mediation. And we're going to talk a little bit about what these are, why they're important for students and also for businesses. But I just wanted to lay that foundation down. So quickly, Jonathan, I think we'll come to you first. For the people who are not familiar with mediation specifically, could you just give us a quick intro into what it is?
Thanks, Aditya. Hope I'm clear to everyone who's joining in, and thank you so much for joining in today. It's of course I spent the last couple of years at one of India's premier mediation institutes, that is the CAMP Arbitration and Mediation Practice, based in Bangalore. And back there at CAMP, we would like to say that mediation is nothing but a facilitated negotiation. Right? It's as simple as that when you try and break it down. It's two parties who have tried to have a conversation, who have tried to have a dialogue, who have tried to negotiate when they are in a dispute, and for whatever reason struggle to get that done. And they might have had their lawyers with them, they might have not had their lawyers with them, but there has been some kind of effort put into try and resolve the dispute, but it has failed. And so now these two parties, or it could be multiple parties, along with their lawyers, along with their stakeholders, influencers, councils, whoever is really advising them, come on board and say, let's try and mediate this. Let's try and bring a third neutral party who is a trained, skilled, experienced neutral, a mediator, to come and resolve this dispute. So that's basically what mediation is. A mediator helps keep the negotiations on, keep the communication on, so the parties themselves can resolve the dispute. So I think with this explanation, I think the whole understanding of self-determination and the neutrality of mediation and the voluntariness of mediation comes through.
Right. So it's parties being able to take control to an extent in a way with regard to solving their or resolving their dispute through the help of a neutral mediator. Okay, thank you, Jonathan. Dr. Nain, if I can come to you for the second, which is just a quick introduction to arbitration. Thanks.
I will. Hi. Thanks for letting me in. Thanks for giving me a chance to talk. I'll break it into simple things. Arbitration is an alternative dispute resolution methodology. Alternative to what? Alternate to court system, alternate to litigation as we know it. The MyBAP in India is a court. If there is a dispute, so to get away from a court system, the alternative is arbitration. It is a procedure where it is a dispute resolution modality.
Go ahead.
Yeah, it's an alternative dispute resolution modality where the parties agree jointly to opt for arbitration. It is by agreement. The arbitrator can be appointed by the parties jointly. The procedures to the procedural rules to the arbitration can be decided by the parties jointly. What they will pay the arbitrator will be decided by the arbitrators jointly, and within how long they want an award can also be decided by the parties jointly. So it's a simple, absolutely simple procedure, which is structurally outside the court system, but it still has a mega legal umbrella, and it can be very quick.
Right, and of course, it's not only is it internationally recognized in practice, but it's also covered under and a space is made for it under the Arbitration and Conciliation Act within India.
Yeah, it's got a legal umbrella which is very big.
Yeah, okay, thanks for that. Gokul, I know we're all very passionate about alternative dispute resolution, mediation, arbitration, but really, why should anyone care, right? So, especially for young people who are studying law, why should they care, and why should they care today? Like, how does it affect their lives? You're on mute.
There is an obvious bias, unfortunately, that I have for ADR. I believe that the manner in which ADR has been created, the manner in which ADR is structured, itself it caters towards quick resolution of a dispute. The system of dispute resolution that we have, which currently is being used under the litigation system, is burdened by a lot of the sheer volume of cases that it is expected to handle. So structurally, there are a few things that are very advantageous if you choose ADR as a system of dispute resolution in India. We are a society in which we are not hesitant to take our disputes to another person to resolve. We've done that through the years, taking our problems to elders, taking up our problems to village council leaders and things like that. And that's always been a part of our culture. But the systematic adoption of a litigation system post the British has streamlined the process of dispute resolution. The problem with that is the fact that the legal education and the current structure of the legal system itself is struggling. And my answer is based basically on two primary facts. Prior to the pandemic also happening, there was a lot of burden on the litigation-based judicial system of dispute resolution. We had a very, very large pendency of cases, whether it was at the lower courts or at the constitutional courts like the High Court or the Supreme Court. There was a large pendency of cases. This, unfortunately, because of the pandemic, has been exaggerated to an extent that was that has been unprecedented. Suddenly we had a space of time wherein no dispute resolution was happening. So the court systems took close to about 3 to 4 months to figure out how to move online. So there was a pendency of about, because the pandemic didn't arrive with a warning. It suddenly just, everything just needed to be shut down. We suddenly went into a complete lockdown, and there was a 3 or 4 month period during which no activity took place. Even after that began, the activity finally again began, we had a very few cases being taken up on a daily basis because the judges were getting used to a resolution which is being done online. So an average judge who could handle close to about 40 matters daily was reduced to handling only about 10 matters. Now, this further increased the pendency of cases. This time, the courts realized that we need assistance from alternative dispute resolution systems to take the burden off and give speedy justice. So what happened was legislations were drafted. Courts themselves started promoting matters saying, please try out mediation and please try out arbitration. Now, why this happened was both of these systems, since they are customized towards the disputing parties, can be very easily taken online. Now, this moved online. This is one of the primary reasons why lawyers today or law students today should study mediation. Number one, because the litigation system in itself can't handle the pressure. So the obvious solution to the problem that the typical system of dispute resolution or the landscape is facing is to move on to an alternative dispute. There is no other alternative. Secondly, also because the typical Indian legal studies system does not focus on ADR. Now, if you look at a typical 3-year or a 5-year syllabus, colleges are spending hardly 60 hours, a 4-credit program trying to teach ADR. That is all the more reason why students should start learning ADR on their own, because the typical legal system is catering only in one direction, which is litigation. They're not catering in the direction of ADR. And that's why learning that becomes even more important today and in the future. It will be one of the most viable solutions available.
Right. Thanks, Gokul. And in fact, that's one of the reasons we decided to launch these 2 courses, right? The course on arbitration, which we've launched in partnership with ASCL, and the one on mediation that's coming up next month, because there just isn't that much quality education in the space around. And of course, we'll be putting the link to that in the chat box as well. Yeah, so for those people who are interested, please put your questions in the chat box. We've begun to get them, and I will pick those up as well. Mr. Nain, just coming to you, taking off from the pendency of cases issue that Gokul was talking about. I know that we've had a discussion about this. Do you want to shed some light on that as well?
Yeah, these statistics are announced today. I mean, there's an article in the newspaper which says there are 71,000 cases pending in the Supreme Court of India, of which 56,000 are civil matters, 15,000 are criminal matters. Approximately 11,000 of these cases have been pending for over 10 years. The high courts of India, there are 25 high courts in India. The total pendency of cases is a staggering 59 lakh, of which the Allahabad High Court has 21 lakh cases pending, which is approximately 20% of the total in just one high court. And Bombay, which is the commercial capital of India, has close to 6 lakh cases pending in the Bombay High Court. This is the current situation of, if I put a guess estimate for us to resolve this, if we go at the existing pace, could take us 30, 40 years. So the need for ADR, alternative dispute resolution, is right there in front of us. The numbers speak the story.
Yeah, thanks for that. Yeah, Jonathan, please go ahead.
Just to add to what Dr. Nain just said, I did this convenient math some time ago when I was doing my TEDx talk on a multi-door dispute resolution system. And I did this math where it said that considering the number of high court cases pending in Indian courts today, a normal litigant has around 3 minutes with a judge. 3 minutes, within 3 minutes. I mean, it's a convenient math. I'm just trying to do averages here. But 3 minutes to convince the judge whether the judge should decide in their favor or not. So just think about that. I know it's convenient math, but just the fact that's the number of cases that we're working with in the country.
And even if we have judicial reform, right, which I hope we continue to have, just judicial reform isn't really going to solve the issue when the numbers are this staggering. So you need ADR to come in and lighten the load, and then after the lightened load, maybe you can have judicial reform do a better job of the cases that really need to go to litigation. Because no one here is saying that we want to do away with litigation. That's always going to be there. We're trying to explore how to solve many more disputes before we reach the court system, rather than replace the court system. So because there are some questions that are coming up here, I think, Gokul, I'll pick one of those up to begin with as well. So maybe, Jonathan, maybe you want to, since this is legal one, I'll go with Gokul first with this, and then Jonathan will come to mediation. So what's the legal validation of alternative dispute resolution in our legal system? So maybe Gokul, talk a little bit about arbitration, and then Jonathan can talk about mediation?
See, the question basically, I'm presuming, is about the validity of a decision passed either by an arbitrator or a mediator. I'm presuming that's the direction in which the question is posed. Now, arbitration is very, very simple, since it goes into the Arbitration and Conciliation Act. The power that has been given to the arbitrator is very clearly enumerated under the Arbitration and Conciliation Act. So that's an undebatable situation. Just like the judicial court system has authority given, the Arbitration Conciliation Act specifically gives authority to the arbitrator also. The lack of clarity actually comes with respect to mediation or mediators, decisions passed by mediators. I'll just give a very brief introduction. I'll let Jonathan take over from there. The ability of a mediator to pass a resolution is, as of right now, not determined by any legislation, because we don't have a mediation legislation. So that's why the confusion. The solution that has been found is we're trying to club it and bring it under the ambit of the Conciliation Act, the arbitration and the conciliation part of the Arbitration and Conciliation Act, to give it some kind of legal validity. Now, in this regard, and Jonathan, please take over from here, there are two types of problems that are confronted. First of all, if it is a court-annexed mediation, wherein a court has referred a matter to mediation, like, for example, the consumer court says, please mediate this matter, and the mediator is brought in by the consumer court to mediate a dispute which is in front of the consumer court. Secondly, there's a private mediation which is taking place, where the parties have gone directly to a mediator, a private mediation institution, and asked them to resolve a dispute. The methodology for giving validity to the settlement agreement that the mediator helps come up with is different in both the situations. Jonathan, do you want to take over from here?
Yes, I'll do that. I just want to kind of, so for everyone else who is going to pop up more questions in the chat box, ADR is a very, very wide term, okay? So that's going to kind of alter our responses to a bit. So if you're talking something specific to arbitration, then please say arbitration. Or if you want something specific to mediation, then say mediation, because that might just alter our responses slightly. And I believe the understanding for this question is basically how valid is mediation. And I just want to reframe slightly what Gokul said, because I know he responded to that question with the context of what was asked, but Gokul talked about a mediator's decisions, and just want to reframe that by saying that a mediator does not decide, a mediator does not pass solutions or give orders or pass judgments. But what Gokul meant is that a mediator's signature on a mediator settlement agreement is of no value right now, all right? Because at the end of the day, it cannot be enforced. It remains as a binding contract between two parties who had come to a private mediation. This is, of course, pre-litigation, not court mediation. It's pre-litigation mediation, private mediation. The signatures that matter on that mediated settlement agreement are the two parties, because they have together decided on basically coming to those terms. Okay, so now what happens if they go through a private mediation path? Then that becomes a binding contract, yes, but it's not enforceable. So say one party dishonors that mediated settlement agreement, they will have to go back to court and begin the entire litigation process again. But with the new law coming up, the new mediation law on the horizon, that should take care of things, where a mediated settlement agreement now, which will have a mediator signature, will be as good as an arbitrator's award, as good as a court decree. So that should be taken care of, hopefully, in the next 6 to 12 months. But as Gokul was saying, for now, the cheat code to this is basically you start that process as a conciliation, you end it as a conciliation, so it becomes a conciliator settlement agreement, which is enforceable in court. So in short, yes, the mediation process is very much a legal process, very much taken care of by a lot of statutes that can help with the procedural aspects of it.
Okay, thanks, Jonathan. Dr. Nain, do you want to answer that or take up another
I want
question?
to come in on this
Okay.
from respect to arbitration. The arbitration is under the Arbitration Conciliation Act 1996, and the interesting point, which very few people are aware, is that an arbitrator's award is equivalent to court decree. It can just go for execution to the court. The award does not need validation by a judge unless it is challenged. So it's totally legal. The award can go for execution straight away. And talking of mediation, the via media shortcut is if a mediation is started today without a mediation act, the same decision can be converted into a consent award through an arbitrator or a conciliation award as per the act. So it is totally legal.
Okay.
It has a sound legal umbrella.
All right. And that's, one of the things that people who haven't got exposure to ADR earlier take time to realize is that the dispute is yours. It's like yours to deal with. It's in your hands if you want it to be in your hands. If you wanted to go to a court system, you can do that. But through mediation and arbitration, you can actually control a lot of the parameters. And this brings me to the next question by Udayan Ade, which is there a way mediation or arbitration, he's used both / mediation / arbitration, can be made compulsory before going to court, at least for specific types of cases? So Dr. Nayan, why don't you take this first and then we'll move from there on arbitration.
The answer is simple. You can, it's very common to have what is called a multi-layer dispute resolution clause. It's called the MEDAB clause. The MEDAB clause is that the parties will go through mediation for a specified period of time, say 6 months, or even it could be a NEGAB clause, negotiation arbitration. If within that specified period, they are not able to resolve the dispute, the matter goes to arbitration. The only catch is that the mediator cannot be on the arbitral tribunal. But yes, multi-layer, you hit the nail on the head. A multi-layer clause is perhaps the best clause, and that's what one is going to see down the years.
And that makes it compulsory. Jonathan,
Yeah.
do you want to comment on that?
Sorry, Aditya, can you just repeat that question?
Yeah. Is there a way mediation can be made compulsory before going to court, at least for specific types of cases?
Well, first of all, it's a voluntary process. Yes, so we have to safeguard the voluntary principle of mediation. As Dr. Nayan just said, the clause, having a mediation clause, does incentivize the parties to go try it out. Once again, coming back to the new law, and Section 6 in the new law talks about this mandatory 2 sessions of mediations, which has got some members of our legal community a bit worried and concerned as to how it's going to work. But what the law is basically saying is go and experience what mediation is, get yourself educated that this process exists, and you can actually take advantage of this process, which is an amicable settlement process. So the new law is going to try and push parties to try mediation for at least 2 sessions in civil and commercial cases, at least, before they go out and file a suit. So that push is being once again given by the new legislation, which is on the horizon, not yet made into a law, of course.
Okay, thanks. Gokul, do you want to come in, or should I move on to another question? You're on mute.
There are a lot of legislations which are now being created to specifically push mediation, like has been mentioned by Dr. Nayan and Jonathan. Something as simple like the court fees that we pay in front of a court will be completely given back to the parties if they resolve the matter through mediation or ADR or arbitration. So these are incentives that the courts are giving to try and incentivize the idea of alternative dispute resolution. So if you've gone and settled the matter, take the entire court fees that you've put in front of the court back. So the idea basically being that the legislation is trying to push, the courts are trying to push alternative dispute resolution because that's the need of the hour.
Thanks, Gokul. So, just to bring in one point here, suppose, you're an author and you have a contract with a publisher. And if it's a well-drafted arbitration clause, especially for arbitration, if it's well-drafted, then yes, it does make it compulsory for you to try, unless both parties then say, look, we both agree that we don't want to do this, right? But one party can't force your hand into saying that, no, I don't want to arbitrate anymore. So Pratap Pawar asks, what does KTR mean?
I answered that question.
Oh, you did? Okay, sorry. Is Lok Adalat a type of ADR system in court? Ripun Sood. Is Lok Adalat a type of, does anyone specifically want to take that question? Yeah, Jonathan.
Aditya, no, sorry, I'm not taking that question, but I just want to, I feel like I need a bit closure to the previous question.
Sure.
On, this pursuit of other, making ADR mandatory, okay? So here's my take on it. I think there are certain disputes that are fit for amicable resolution. And what is amicable resolution? I'm speaking of mediation's perspective here. You cannot make someone obligated to go and try and resolve a dispute that's concerning their lives, their livelihoods, their social lives, mental lives, physiological lives, whatever it is. So there are certain disputes that can be mediated and certain disputes that cannot be mediated. And even the different legislations that do mandate mediation, including the new bill that will be passed into a law hopefully soon, they're only saying go and try it out. Mediation continues to remain a voluntary process, which means that after 2 sessions, you can just simply tell the mediator, sorry, this is not working out for me, I'm out. I want to go and pursue the adversarial path. I want to go to court. So the mandate is just to go and try it out, and no one's forcing you to settle. That's
Right.
absolutely not what the mandate says.
Yeah, so that would be a key distinction between mediation and arbitration in
Yes,
the
yes.
ADR
Correct.
spectrum.
Correct.
Yeah. Okay. Is Lok Adalat a type of ADR system in court? Dr. Nain, you want to come in?
Yep. Lok Adalat is also an alternative dispute resolution system. It's used more at the panchayat and the rural areas at the pre-litigation stage to resolve the disputes amicably. You can say a Lok Adalat is an upgrade on the old panchayat method of deciding and very similar to mediation. But is it litigation? No. Is it arbitration? No, because litigation and arbitration give firm awards. Lok Adalat is a dispute resolution mechanism which is conciliatory and mediative in approach, and it's not really binding. Is there to resolve disputes amicably. But yes, it's part of ADR.
Jonathan, do you want to come in there maybe if you with the mediation bit of it or no?
Yeah, I completely agree with Dr. Nain. Just maybe I would probably consider it more as a form of conciliation than mediation, because in this case, the Lok Adalat does offer a suggestion, offers a solution to both parties and say, reading your case, understanding the facts of the case, I think this is the fair way to go ahead with this. So there is a solution suggested or offered by the Lok Adalat,
right,
which is a more proactive kind of activity done by this neutral, and so it's more leaning towards conciliation than mediation. But yes, otherwise, exactly what Dr. Nain said.
Got it. Thank you, Gokul. I have a question for you. Yeah.
Aditya, just to add one more point to this thing. Just to create that distinction, carrying Jonathan's point forward, it's very necessary to understand that mediation as a process, we strictly do not offer suggestions. Our work is to follow the process of mediation to help facilitate a negotiation between the parties. But that help does not, or the assistance does not include suggesting, maybe you should settle for this, maybe you should settle for that. That's not our job. That is strictly outside the bounds of what a mediator is allowed or expected to do. Our work is to facilitate the negotiation, not suggest a solution. And that's where Jonathan is coming in.
Again, that's a key distinction between arbitration and mediation, because an arbitrator's job is to, in fact, make decisions and write reasons and issue awards.
Correct.
So in that sense, an arbitrator would be sort of similar to what a judge is and distinct from a mediator. Okay, so we have another question here from Veda. She says, interesting discussion. Thanks, Veda. So can someone who is from a non-legal background also take up mediation as a professional career? Or what does one have to be a lawyer? Maybe we'll do mediation first and then go to arbitration. So Gokul, talk a little bit about mediation, please. You're on mute.
I don't know why I keep muting.
Oh, sorry, I think I muted you. Sorry, that was my mistake.
Yeah, that's what I was wondering. Why am I going on mute every time? Okay. All right. So the good part is there is no legal requirement for mediators in India to be lawyers. Now, in fact, even in the bill that has been proposed before the parliament, there is no such requirement which has been placed. Internationally also, the understanding is that you don't have to be a lawyer or a legal professional who can only then become a mediator. But because please remember, what is most important in mediation is an understanding of the process of dispute resolution, not necessarily requiring the mediator to be a subject matter expert to be able to resolve. because what the mediator is using is skills of mediation to help facilitate constructive conversation between the parties to achieve a desired goal. So I might be, see, for example, I'm a trained legal professional, but I might be handling a dispute with respect to a medical issue about which I have no clue. I'm not a doctor. I don't have a clue about the medical profession, but I can help mediate that dispute because my expertise with respect to the law over there is irrelevant to the outcome that we are trying to achieve. So in a nutshell, you don't have to be a legal professional. This is one of those fields which is allowing other professionals from other fields to become a part of the dispute resolution landscape in India. And that's why the future looks so bright, because if it is restricted only to one community, the possibility of providing a solution is lesser. If we allow professionals from all walks of life to come in, our pendency of cases and our ultimate ability to provide speedy justice would be much faster.
Thanks, Gokul. Dr. Nayan, do you want to just address that question for
I will
arbitration?
actually answer that question by giving you my background so that you understand. I'm not a lawyer. I'm a mechanical engineer with a career in marketing, a PhD in HR, and a fellowship in arbitration from the Singapore Institute of Arbitration, and a membership from the Chartered Institute of Arbitrators, UK. You do not need to be a lawyer to get into arbitration. What you need is A, common sense in very large doses, B, an understanding of contracts, the law of contracts, and the technicality and the legality to understand how to write a legally valid arbitration award which cannot be challenged. As simple as that. I must tell you that the book we have written on arbitration, FAQs on arbitration, has about 300 questions. To the best of my knowledge, there is not a single legal word in the book at all. Arbitration is non-legal. Any of you in this program who are not lawyers can get into arbitration. Any young lawyers who want to get into litigation can also get into arbitration. Any students of law can add ADR to your asset book and get into it with or without the legal degree. I hope that answers the question.
Yeah, I think that was perfect. I think Jonathan wanted to come in there and contribute.
Just to kind of follow up on what Gokul and Dr. Nayan have said, and the reason why Dr. Nayan is pushing for this very much is that there is a seat at the table in both mediation and arbitration for a counsel, for a lawyer, and that becomes a mediation lawyer or an arbitration lawyer. But to be an arbitrator or a mediator, you do not need to have a legal background. So I just want to make that very clear. I myself am not a practicing lawyer. So that's the thing. You can be a mediator or you can be an arbitrator without being in a legal profession. But there is a place for a mediation lawyer, for an arbitration lawyer, a counsel who represents the parties, but they become part of the negotiation team or the arbitration team in that case. Another point to just drive this through is the first batch of who did their post-graduation in mediation and conflict resolution, who have just graduated from MNLU Mumbai. I think more than 70% of that batch of professionals who are not lawyers at all. You have police people, you have psychologists, you have educators, you have people of all walks of life who are part of this. So the future for mediators who are not part of the legal profession is bright in India. That's all I can say.
I think if I can just add a little bit here, if you just Google, mediation or arbitration institutes in India, you'll find a list of them. In fact, we have a collated list, which we can also make available in some form. And if you go through the kinds of arbitrators and mediators empaneled or associated with these institutions, you'll see that some of them are lawyers, but a majority of them are not lawyers. And there are people from all walks of life who are in fact participating in this field. There's a question from Hemant Patil. I think it's, in view of pendency, can the court enforce ADR as a mandatory? So I think we've answered this question already. If there's more discussion that you'd want to have, Mr. Patil, we can always do that. I think after we end the session as well. Ashutosh Kumar says, how successful is ADR in India, especially considering, talking about arbitration. So how successful is arbitration in India, especially considering the high cost of arbitration And does this mean it's only suited for fat cat corporates? I think great question. Also, can the aggrieved party go to court and enjoy the length of justice? Dr. Nain, maybe you first.
Yeah, from your question frame, the way you framed the question, I think you have some exposure to arbitration or legality. So I'll answer the question in practical terms. Large corporate disputes, which is where arbitration takes place mostly, globally, 80 to 85% of the disputes go through arbitration. In India, it's only 15 to 20% because we are a litigation-centric country. I jokingly say that we have a culture of litigation and arbitration. So in India, the runway to catch up is very large. Is arbitration expensive? Yes, arbitration is expensive, but is it cost effective? It is more cost effective than litigation for the simple reason that the time, money, and loss of business opportunity which you have when you go through a court system, the extra upfront cost in arbitration pales in comparison. So it's a far more effective method. In fact, between two parties, you can decide that you want your award within 6 months flat. Two parties can decide to have what is called documents only arbitration or fast track arbitration, in which case the arbitrator is mandated by law to give you a judgment in 6 months, an award in 6 months, which no court can give you. Are you free to go to litigation after arbitration? No. Once you have decided to arbitrate and gone through the process of arbitration, nobody can wake up tomorrow morning and say, I didn't like this, so I want to go to the other route. No, the deal is done. You know, the I's are dotted and the T's are crossed. So if you want to get into litigation, do not sign an arbitration clause. If you have signed an arbitration clause, you cannot exit that unless the other party also wants to exit. I hope I've answered that.
You can't unilaterally exit it.
Yeah.
There's always an exit route as long as both parties are willing.
Yeah.
So you always have recourse to the court system if you so wish, if both parties want it. So Ashutosh Kumar has raised his hand. I'll just come to you if we can just go through some. Yeah.
If you give me 30 seconds, I'm
Yeah,
reading.
sure.
I'm reading Hemant's question again, and I'm reading it differently. So he says, in the view of pendency, can the court enforce ADR as mandatory mechanism to litigants? I'm going to take up this question because the way I interpret it from a mediation perspective, Hemant. And are you saying, can the judge or does the judiciary have the responsibility to say, hey, this does not need to be in my courtroom? Can a learned judge who understands the value of mediation say, this does not need to be in my courtroom, this can be easily resolved through mediation? Yes, the judge can do a lot there. Of course, under section 89 of the CPC, you know that the judge can refer a case to mediation, either to a court-annexed mediation center or to an ad hoc private mediator or to a private mediation center. All right. And now, even in an arbitration setting under section 11 of the Arbitration and Conciliation Act, when the parties go to the judge to say that we cannot decide on an arbitrator, can you help us get an arbitrator? You need to help us decide to get an arbitrator. The judge can at that point of time pause that proceeding and say, have you all tried mediation yet? And refer them to mediation again. So the judiciary does have a responsibility. The judges can suggest, as I said earlier, after 1 or 2 sessions, the parties can just return back and say, sorry, this is not working. So I just wanted to take that up.
Thanks for pointing that out. Yeah, Mr. Network.
I'll give you a practical example, Hemant. A very large corporate engineering business group in Western India, having a combined turnover of more than 35 or 40,000 crores divided between 3 family members, approached the Supreme Court for a dispute within the family. They were sent to mediation. The mediation was unsuccessful. 3 parties were represented by the 3 of the senior-most counsels in the country at fantastic prices. The Supreme Court judge informally came back and said, no, I want you to give it another effort at mediation before you come back to a court. And I think I'll give you another 1 month or so. I mean, I won't name the parties, but do they have a legal role to play? They have a very practical role to play. Is that practical role effective? Highly effective. It's a nudge. It's a nudge. And in this matter of 3 siblings in a family dispute, they've been forced to go back to mediation second time. So yes, okay. Your question is fantastic.
Thanks. I'm just continuing with the questions on the chat box. So Shriya Tripathi asked, parties to the dispute sometimes don't want to settle in mediation, especially matrimonial disputes. And after mediation, they come back to the courts. So can courts make ADR or mediation mandatory? I think let's specifically talk about matrimonial disputes here because we can bring in some nuance there as well. Gokul, if you want to take that.
So matrimonial disputes actually lend very favorably to mediation. Why they do that is, and a lot of matrimonial disputes actually get settled through mediation, primarily because mediation is a system where somebody else is not determining the rights of the parties and they are able to determine their own rights. Please remember the words used by Jonathan. This is a settlement agreement. This is not a decision. It is not an award. It's a settlement agreement, which basically means if there is party A and B in a matrimonial dispute, they don't need to do anything which they don't want to do. So the good part about mediation is the fact that nobody else is judging from any perspective whether your view of the dispute as a husband or a wife to the problem is correct or not. Because as a mediator, I'm not passing a decision. I have the ability in a mediation to empathize with the feeling of the parties, which something like a judicial system under litigation does not have the liberty to do. They're going to look at facts, they're going to look at the law, and they're going to interpret the facts in the context of the law and pass a decision determining the rights of the parties. In mediation, we don't need to do that. It's a place where there is a possibility of finding closure, not only with respect to the dispute, but with respect to the feelings of the parties who have, in all probability, not been felt heard in marriage. Mediation gives you an opportunity to do that. But yes, if the matter does not reach settlement through mediation, you can always go back to court. After going back to court, there are these instances also which have happened in cases that I have mediated. Parties have said, this is not working out for us. We will try and settle our matter in litigation. They've gone into litigation, spent 2 years in litigation, realized that the matter's not gone anywhere. Then they've come back to mediation saying, nahin, nahin, ye behtar hai. Let's just settle the matter in mediation. So we don't dissuade people from trying to go into litigation because litigation gives them a reality check. And then they come back to a dispute resolution mechanism like mediation, and they're able to find closure because they realize that determining their own rights is far more, leaves them far more in control than having somebody else decide their rights. I hope that answers the question, Aditya, with respect to matrimonial disputes.
Yeah, and I think that also brings in, especially in matrimonial disputes, one very important factor of ADR, which is confidentiality. So of course, as people know, once you're in the court system, everything is public or can be public. Whereas in mediation and arbitration, you can maintain confidentiality, which for a lot of people in a family or matrimonial dispute becomes extremely important.
Correct.
Yes, Mr.
Matrimonial disputes cannot be arbitrated.
Right. Yeah. Matrimonial disputes, and there are a bunch of other disputes as well, which of course you'll find the entire list in our book. Let me plug the book, which I put the link also in the chat box. Please take a look at that. So in our book, FAQs on arbitration in India. So Subrata Kumar Panda says means ADR is in good faith of the parties involved, especially in mediation. I think that is true, but I think Jonathan, if you want to just come in there, I think that's been answered. If you have anything more to add.
Yeah, I mean, Gokul said it. It's because the parties come together and make their own decision. The chances of them going back and saying, no, I don't agree with this is very, very slim. From our experience, that has never happened to me, at least. Gokul might have a similar situation where, because I think a good mediator who allows the parties to make a decision right from the first word till the last word is never going to have an instance where the party changes their mind the next morning. Because remember, a good mediator does not only look at the two parties in the dispute. A good mediator also understands who are the people who are influencing the parties. So in a marriage, it could be in-laws, it could be, extended family, it could be a lot of things. In a commercial corporate dispute, it could be stakeholders, investors, whoever else is involved. So a mediator makes sure that all these people's advice is also taken into consideration before they sign on the mediated settlement agreement.
Right.
So the chances of them going back on their word is very, very less.
Okay,
I just want to go on a limb here, by the way, and say this, is that for people who I don't know if there is people who are fishing to understand whether mediation is the best way to handle divorce disputes, I would say it's totally the way. But get your lawyers involved a little later. Because a lot of the things that you discuss in mediation, your lawyer does not need to be there. That's quite private, right? Especially in divorce mediations. You can have almost 75% of your mediation process done with you and your spouse. And towards the end, when you're reaching a settlement agreement, that's when you bring in the lawyers who can help you draft stuff out. You don't need your lawyers to be there to listen to all your private matters. And yeah, you bring them in when you're ready to settle. So I'm going to go out on the limb and say that, because that's the fact. Gokul is already nodding to that.
Yeah. No, I think it's best to be direct about these things, right? I just want to bring in a matter of, for those of you who have to leave, thank you so much for joining us. You will hear from us again. We will continue this as long as there are questions. We are happy to do that. So if you came in and you have to run, enjoy your evening, and thanks a lot for joining us.
Aditya, just before we wind up, for the people who need to leave, for the people who need to leave, there's a question that's there at the bottom which talks about who can become a mediator and how can you become a mediator. Can we just answer that question first out of turn? Please, and then take it on? Dr. Bharat, do you want to take on the question with respect to arbitrator, and then Jonathan can take on about the mediator?
Yeah. To become an arbitrator, there are various arbitral institutions having multiple courses. One of the best ones in India is the Indian Institute of Arbitration and Mediation in Kochi. They have a beginner's course, which is a 3-day certificate program. If you want to go a little more high gear, the Chartered Institute of Arbitrators in London, they have what is called an education pathway on their website. Look at that. There are various levels, from associate member to a fellowship, which is where I went. Similarly, the Singapore Institute of Arbitrators has a membership level and a fellowship level, which is what I did. So there are very many options available in institutions within India and internationally. These entry-level courses of 2 and 3 days, which give you a basic understanding, are now also online.
And if you liked us and you think you'd want to study this with us as well, of course, we have our own course, which we've spoken about, and which we will tell you about in our follow-up email as well. So that's also an option for arbitration. And then there's a mediation course coming up next month as well.
And our arbitration course, which is coming up, is actually geared to...
Sorry, you're on mute. I muted you by mistake. I'm so sorry.
Some of the, our arbitration course online, which is coming up, has been geared very largely for people who want to begin from ground zero, have no background, or students who want to add arbitration to their toolkit. So this course literally starts from ground zero and takes you up.
Can I just add to this, Dr. Nain, as in Dr. Bharat Nain, because you're both Dr. Nains. What I'd like to add is, if you look at your curriculum, and I'm talking specifically about law students, because primarily we've got lawyers and law students over here. If you're not a law student, then it doesn't even, then the question is very obvious to you. You'll need to do a fundamental course, something like what we are offering, to be able to understand it. Even if you're looking at a law student, a 3-year LLB student or a 5-year LLB student, in that entire spectrum of studies that you do, in a 5-year LLB course, for example, for the first 2 years, you're just studying subjects like English, political science, the history of legal systems of courts, and maybe being introduced to tort and contract, and that too maybe in the 4th semester. In that entire 5 years of learning, which is divided into 10 semesters, there's only one paper which is there on arbitration, which is there on ADR, which focuses, that one paper also, which is a 60-hour paper, focuses primarily on arbitration and literally nothing on mediation. It's not possible in 5 years to study arbitration the way it needs to be studied to become an arbitration professional. Let's be very clear about that. You will not be able to understand it, because they're not talking about, if you look at the entire structure of the arbitration course that you would be expected to do, which surprisingly in a lot of colleges is still an optional program. It's not even a mandatory program, which is very surprising, is something that they won't even focus on the arbitral award. They won't focus on writing of the arbitral award, or what should a contract look like and things like that. You will need to have hands-on experience in terms of understanding what arbitration is, how it works, what its nuances are, how it can be applied, and how do you make a career out of it. Mediation, again, goes without saying, because mediation, there is absolutely no discussion on mediation. There will be a little bit, very brief discussion on conciliation, and conciliation and mediation is used synonymously when it is not the same, and you will not get experience with respect to mediation also. So the purpose with which we've started off these programs is to give, irrespective of what educational background you belong to, a firm foothold in alternative dispute resolution systems, whether it be an ADR, whether it be a mediation system, to get a strong foothold, to understand what the mechanism is, how it works, and how do you move forward and make a career out of it. Jonathan, would you like to take the mediation part on how to on a career path on mediation?
Yeah, very quickly. So firstly, I think, when we talk about trainings and workshops and just getting ourselves skilled, it's not a one-time thing. It's something that you have to think about investing in, say, maybe every 1.5 years or every 2 years, right? And that's why, if you're really passionate about the subject, you have to look into investing into this, say, every 2 years at least, which means that if you have done a 40-hour training in mediation, which is the international standards, you have to think about doing another one in 2 years' time. It's because things are continuously evolving. Another reason why you need to do it is, and for especially, you have all the big names that do your mediation courses, and I'm not trying to push or peddle anything that's liking to me, but you have the ones that CAMP and EMA runs, which is a 40-hour mediation training. You have the mediate.com online mediation training. You have other big trainings and other big names that are doing trainings in India. But I myself have done around 4 40-hour mediation trainings. But the first 2 ones were good. They really gave me a lot of knowledge. But it was the third one where it finally started to sink into me what this concept and what the practice was all. And the reason for that is because I did not do a fundamental course before I went to do a 40-hour course or to do a much larger course. And so my suggestion to everyone who's exploring arbitration or mediation for the first time is to do something that's more fundamental, as Gokul said, that's foundational. So that gives you a lift to go and do something massive. If you're going to go and do a CIO course or a much more massive course which is more intense, then you might just not be ready for it. And you're taking in all this knowledge, but the basics and the foundations have not really sunk into you. So I would suggest you start with the foundational course and build yourself up to something bigger. So that's my only advice on this.
I had a couple of direct messages come to me as well about this. So I'm glad we addressed that question about the career path in mediation and arbitration. And I've provided the link for the arbitration course, our arbitration course, which is already open for enrollment. So for those interested, the link is provided again. So I think a bunch of those questions, Gokul, that you were referring to have now been answered with regard to career paths. But
just one part remains possible to start an independently or take experience with an already established firm with respect to mediation. I think Dr. Bharat already answered the question with respect to arbitration, but maybe a little bit more clarification is required. Vis-a-vis mediation, I will give the requisite answer to that. As of right now, unfortunately, because of the lack of existence of a legislation, we don't know what the process legally of becoming a mediator is. All right. There is no established procedure. We don't have a system. But what you could look at is internationally, how do people get qualified as mediators? Some institutions like the premier institution, one of the premier institutions in India is the Center for Advanced Mediation Practice based out of Bangalore. They've got systems in place where doing a mediation program is just the first part of becoming a mediator. You don't become a mediator just because you've done a course. You have to look at it like flying a plane. You've done a theory exam on flying a plane, you don't become a pilot. You then have to co-pilot a plane where there is a senior instructor and you're the junior pilot. Then you have to do a solo flight. And after that, after you've gained the kind of experience that you have, then you become a mediator. That's the process that I have followed. That's the kind of process Jonathan has followed. That's the kind of process that we suggest anybody who comes into the field should follow. Like, for example, prior to me becoming a mediator, I did shadow mediations, I did co-mediations, I did a lot of pro bono mediations with the Consumer Forum to be able to gain my experience to be able to handle this. But unfortunately, as of today, there is no established process. Institutions have come up with their own processes on how one can become a mediator, and every institution's come up with a different process. But hopefully, with the mediation bill becoming an act, we will have more clarity on how one can become a mediator and what are the steps involved in becoming a mediator.
I think Gokul, I think actually it's not that complicated for a student. They should just get in touch with you, and I think a one-on-one discussion on how to go about it, because there may not be an established legal procedure, I mean legal requirements, but there are many pathways and there are clear pathways.
Correct. That's what I meant.
So I don't want to confuse people too much with that uncertainty. So because I do see people in the questions who are looking to educate themselves on this and get on the path in both mediation and arbitration. For those people, just get in touch with Gokul, me, anyone. You can find all of us on LinkedIn. Get in touch with any of us, and we are happy to have a discussion with you on what's the best way for you to go ahead. Dr. Nain, you already answered one question regarding the finality of an arbitral award.
Correct.
So Deepa had asked if in the mediation, first she says about mediation, if in the mediation the decision is not in favor of one party, can that party further move to litigation? And the second part of the question is, in case of arbitration, can the award is final and cannot be taken further to court, question mark. So Dr. Nain, I think if you want to just quickly just round off that answer for arbitration, and then we'll go to mediation.
An arbitration award is final.
Oh God, I'm so sorry, I muted you again. My bad. Yeah, you're on mute.
An arbitration award is final, can be challenged on extremely limited grounds, and the challenge grounds are that A, the party under some incapacity was not able to present the case, was not given an opportunity to present the case. If the arbitration clause was invalid or notice of appointment of arbitrator was not given, the party was unable to make the representation effectively, or matters were beyond the scope of arbitration, or the procedures followed in the arbitration hearings were not as agreed. So challenge grounds are very limited, or the most common challenge ground is matter of this is against the public policy of India. It's not like a court case where you can go various steps in the litigation process and go right up to the Supreme Court. The challenges grounds are very, very limited, and the award is final.
Yeah. So it's not like, oh, I didn't like the decision, so I'm going to.
No, you can't wake up tomorrow morning and saying I didn't like the decision, so I'm going to go to court now. It's over.
Yeah. So
and that's where the knowledge of how to write a technically and a legally correct award comes in.
Got it. Jonathan, do you want to take the mediation part of that question? If the decision is not in favor of one party, can that party further move for litigation?
Yeah, so I think, as I was saying earlier, it's a binding contract. It's the parties who sign it along with their lawyers. Some mediators choose to sign it, some don't. So in a private mediation, it becomes another contract. And if one party does not like it tomorrow morning, they basically dishonor the contract. If party A dishonors the contract, party B has to basically start a civil suit all over again. So that's how you go along with the mediation bit of it. In a court-referred mediation or a court-annexed mediation, in that case, the mediator signs off on that whatever the parties have agreed to, that goes back to the judge, who now pronounces it as a court decree. So that becomes, I guess, I'm not sure how will that go around. Gokul, can the party appeal to that? I don't think so, because it's a consent.
You're on mute, Gokul.
It's a consent agreement. So especially in.
Aditya, I think you did it again.
I didn't mute you.
I think you. All right. So what we need to understand about this is that, first of all, it's not a decision, like Jonathan had mentioned earlier. It's not a decision. It's an agreement. The parties have agreed to settle the matter on certain terms. All the mediator is doing is assisting the parties to put down the. So there can be two situations. Let me take both of them. One in which the parties have come to a mediator without a lawyer, or where they are represented by lawyers also. Where they're not represented by lawyers, the mediator will assist them to put down the terms of settlement. because they might not be capable of doing it. So the mediator provides that assistance. In case it is they're accompanied with lawyers, then the lawyers will sit down based on the discussion that has been had, put down the terms of settlement of the agreement. Now you can go back and enforce this through a court decree. But once you put this down as a consent settlement agreement, and on the basis of that consent settlement agreement, an award is passed by either, like we said, if it's a med-arb or it's you go back to court. Since there was the consent of the parties, the possibility of them going back and saying, oh, I don't like what I had decided to do, and therefore I would like to change my mind and go ahead with litigation. No, that's not going to happen. So because it is with your permission that the settlement agreement has been created. Therefore, before you finally decide what you need to do, you can always go back, review, think about it. Once the settlement agreement goes through a legal process of a court, then you can't go back and say, oh, oops, I made a mistake. Let's figure this out again.
Yeah. I think, and Arya Kekere, sorry if I'm pronouncing it wrong, but she asked, what steps or measures should a freshly graduated law student take to be an arbitrator? I think, Arya, we've to an extent answered that question. I think it's best if you're interested in this, get in touch with us so that we can actually have a more deeper discussion on what kind of course would be right for you. I think we'd all be happy to do that for you. So feel free to get in touch with us later. Mehek asks, can a person appeal against a mediation, arbitration? We just answered that. That has been concluded. I think we answered that question as well about a decision, mediation not being a decision. It's an agreement, and the arbitration bit of that has also been answered. Avinash, yeah, Gokul, you want to say
I think
something?
there's one question by Praveen with respect to arbitration. What role does Evidence Act has in arbitration? Is it necessary to comply with Evidence Act in arbitration?
Right. Dr. Nen, do you want to take that?
Yeah, the principles of the Evidence Act are applicable in principle, but the Evidence Act in particular, in totality, and that section 65B, which is the most important. In short, the Evidence Act does not apply, but the principles of the Evidence Act. Now, the caveat here is if one party proceeds as per the, as per the Evidence Act and the other party responds to it, then you can't go back. You have to raise your objection about the Evidence Act right at this stage. Unfortunately, at more than 50% of arbitrations in India, people follow the Evidence Act because the arbitrators tend to be from the litigating field of a retired judiciary, but the Act does not apply. The principles only apply.
So a lot of this actually gets taken care of if you go through institutional arbitration, because these rules and procedures would be laid down and there'd be best practices followed, including with regard to how to use and how it applies with the Act.
Arbitration is so simple. If you educate yourself just a little, read the Arbitration Act. If you're a party and if you're a counsel, read the Arbitration Act 3 times. You will get clarity in terms of how your role should be and how you can make it more effective for you.
Yeah, so I'm just taking a look at where we are on the questions. Avinash, when will the course of mediator and arbitrator start? So our arbitration course is already open for enrollment. It starts in September. It's a cohort-based course. It starts on September 15th. I've provided the link in the chat box as well. Take a look at it and feel free to get in touch. The mediation course will begin, I think, Gokul, next month as well?
October 15th.
October 15th. Okay, great. And once the link for that is available, we'll share that with all participants as well. Vedanti, is there some sort of time limit, or is there a time limit or some applications related to mediation? I'm not sure I understand that question, Vedanti. If you want to clarify what you mean by that. In the meantime, I'll take another question.
Aditya, just to say, I think Jonathan has a prior engagement at 8 o'clock. He's already at 10 minutes over with that.
Sure, okay.
So Jonathan, in case you need to proceed, please feel free to go ahead. We'll continue over here. I don't have a...
Thanks for joining, Jonathan.
Thanks. This has been a real pleasure, and thank you so much. Everyone has actually stayed on the call, so thank you so much. And do keep in touch with us.
Thank you.
Enjoy your evening. Bye-bye.
Thanks, Jonathan. Thank you so much. Sorry, please go ahead, Aditya.
Yeah, so we are here happy to answer the questions. So I got a direct question, so I won't say the name, but I'm really interested in ADR, but I feel like it's not given that much importance. So should I consider it as a career or opt for something else, as I just completed my last year of BA LLB? Again, for this person, I think a detailed discussion would be in order. Get in touch with us. We'll be more than happy to schedule a call with you and try and guide you through this process based on your specific case. Yeah, so I think it's similar to the Evidence Act question. Prasad asks, does it require for the arbitrator to refer to laws while arbitrating, as it is not mandatory for an arbitrator to be from the legal background? So what's the role played by laws in an arbitration process? Dr. Nanya.
Yeah, there is the Arbitration Act. The Arbitration Act lays down certain mandates which cannot be non-validated. You have to follow that. There has to be a strong understanding of the law of contracts, or contracts in particular, an understanding of tort, and an understanding of how the Arbitration Act wants an award to be written so that it is non-challengeable, or it can withstand challenge. So if you do a strong enough course and do enough reading, it'll give you enough knowledge of the laws to be able to become an arbitrator or even assist in an arbitration matter.
Right.
The most important trick, the most important thing is the ability to write an act which can, an award which can withstand challenges.
Okay. Give me a second. Oops, I seem to have lost the chat box. One. Chat box, where are you? Gokul, can you see the chat box?
Yeah.
Can you take a question? Yeah.
I don't think there's anything that we haven't answered as of yet. Apart from the fact that I just want to throw a little bit of light on the idea of career in arbitration and mediation. Like Dr. Nain is an arbitrator sitting in front of us, not from the legal profession or the community of lawyers, to be more precisely put, and still a part of the dispute resolution mechanism. Jonathan and I both are not practicing lawyers, and however, we are mediators. So a career in alternative dispute resolution is very much a reality today. It's been a struggle. I will not deny the fact that it's not easy, because India is now waking up to ADR. I'm honestly of the opinion that we would not have been here had it not been for the pandemic. It is because of the pandemic that our hand has been forced, wherein lawyers, to become what we call holistic lawyers, it is imperative now today that lawyers and law students and legal professionals understand ADR a lot more than was required maybe in 2019 or early 2020 prior to the pandemic. Now it's more important than it has ever been. And this reliance and importance on ADR is only going to increase, because we can see the possibility of a brighter future in the dispute resolution landscape. The possibility looks very bright. And because the possibility looks bright, the focus and the impetus now is going to move towards ADR, because the legal system through litigation has had all the focus till now. And now the realization is coming on that we cannot tend to ignore ADR. It's literally been ignored, because if you look at any kind of established system for alternative dispute resolution prior to the 1996 Act of Arbitration and Conciliation, there was literally no conversation about it. And even in the Arbitration and Conciliation Act 1996, we just have agreements in which arbitral clauses, and that too very shabbily drafted arbitral clauses, are there, which have focused on ADR. But all of that is changing. My opinion is a lot of the pendency of cases, if ADR is allowed to take wings like it has the potential to do, the situation that we are in right now will resolve itself. We'll be in much better position in 2030. By 2030, there will be more arbitrators who are non-legal fraternity, are not from the legal fraternity. There will be a lot more mediators available, and therefore dispute resolution services will become a career path in themselves. So everybody will not want to become a judge to be a dispute resolution service provider. People will turn towards arbitration. People will turn towards mediation for dispute resolution services. And that's going to become a separate career path altogether. Law schools and legal professionals will have to start focusing on it. It is my prediction for the future. And according to me, it looks very bright.
Okay. In fact, here's the thing, and of course, Gokul, you are you have a legal background, you have an LLM in law, etc. Although you're not a practicing lawyer, but for someone like me who comes to this from, let's call it a business background, it seems to me like a no-brainer that if I'm dealing with a law firm, I want those guys to have a really, really strong grasp of ADR. I mean, it seems to be mind-boggling that any law firm would not have excellent ADR services as well.
Correct.
Because
Correct.
any contract that I read, and Gokul and I were discussing this, absolutely any contract you pick up right now, if it's a commercial contract, probably has an arbitration clause in that, which means you have to arbitrate.
Yes.
So then if you have a contract in which you have to arbitrate, and you don't have arbitrators or you don't have lawyers who understand arbitration, what's going on? So it seems again to me a no-brainer that has to catch up. And as a law student, because all three of us have been deeply involved in education, right? Dr. Nain, Gokul, and I, we've been involved in education for a while now. For you to stand out among the sea of LLBs and lawyers, you always need to keep adding value to yourself. And I think ADR is that obvious choice. Whether you choose mediation, arbitration, or combination of both is up to you. But yeah, I would think about it really seriously if I were a young lawyer or a law student. And the thing is, I go one step further, and I feel even business students should be doing this. I know we don't have too many business students on this call, but I'm on that path where even business people need to understand this, because decision makers need to understand dispute resolution procedures.
Correct.
Imagine the value that you would add to your team there. So that was my two bit about that. Thank you, Rukmini. Thanks a lot for joining. Really happy that you could make it. I'm just going through to see if we have anything.
There's one last question from Vasant.
Okay. So can you please explain in short what are the grounds to challenge the award, arbitral award? We actually answered that. Vasant, it's a list of grounds which the answer to that question is of course available in our book. But if you even Google the Arbitration and Conciliation Act, you'll find the list within there as well. I think Dr. Nain, you actually went through the entire list a while.
Yeah, but I want to add one more point. When you're trying to challenge an award, no new evidence can be submitted. Right. And the grounds for challenge, like which I went through, are just 8 or 9. They're very simple. And the point to keep in mind that there have been enough judgments to say no new evidence can be submitted. The judge cannot reappraise the evidence which is there and has to decide based on the current arbitral records only, on the grounds which are allowed by law, not on any grounds. You can't wake up and say, I don't like this decision. Please consider this point.
Okay. Thanks.
Get in touch with me separately if you want to know a little more. I'll guide you on that.
Yeah, I've put both of our LinkedIn profiles on the chat as well. I'm very active on LinkedIn. I'm very happy to get in touch with people and interact with them. So send me a connection request if you want, that we can get chatting. Same thing for Dr. Nain. Gokul, if you want to put yours as well, I'm sure you'll be sending out emails. Thank you,
Just putting out
really
Preeti's number in case anybody has any query. Preeti is our head of student relations. Preeti Bidwai. I'm putting out her number in case you have any questions or queries or want to set up a meeting with Dr. Bharat, Dr. Aditya, or myself. You can reach out to her and we'll figure something out. She's our point of contact. I'm just putting down her number over here.
Okay. Thanks a lot, Sandeep. Really happy that you found it informative and useful. Um, yeah, I know we have a lot more people still on the call. If anyone has any more questions, maybe you want to ask it, you want to unmute yourself and ask it. We're happy to do that as well. So I think we'll just stay on for a few minutes to see whether more questions arise. In the meantime, Dr. Nayan or Gokul, if you want to just bring up anything that hasn't been covered, please do so. I think we've covered quite a bit.
One point which I'd like to say, what we haven't covered, which is there in the book, is which matters cannot be arbitrated. Can I answer that?
Yeah, please go ahead.
The matters which cannot be arbitrated: A, matrimonial disputes, guardianship of minors, fraud or criminal proceedings, winding up of a company, any matters linked to a trust deed, any industrial relation dispute, blue-collar workers cannot be arbitrated, any competition law disputes, eviction of tenancy and tenants cannot be arbitrated, copyright matters, insolvency matters, and any disputes linked to public law rights cannot be arbitrated. The most important thing is A, matrimonial, B, fraud, C, anything linked to the guardianship of minors, and trust deeds. These are very important points. If there is a tenancy contract and there is a dispute on the deposit, that can be arbitrated. But the tenancy dispute about a tenant occupying or leaving a place cannot be arbitrated.
Okay. Thanks.
Get in touch if there's anything further.
Hemant Patil asks, even taxation?
Taxation has their own tribunal. You have to approach the tax tribunal, because these are matters of public policy of India, and there's separate statutes which govern that.
Thanks, Mr. Patil. It's nice to see you with your video on.
Just to clarify a little bit over here, there can, Mr. Patil, there can be legislations in which arbitration and conciliation, the rules of arbitration and conciliation apply. And the parties are called arbitrators. Like, for example, for settlement of domain name disputes, there is a process called the Domain Name Dispute Resolution Policy of India, it's called the .in DRP, Dispute Resolution Policy. Over there, you have to, the is the Arbitration and Conciliation Act, and the person who's resolving a dispute as per the National Internet Exchange of India is referred to as an arbitrator. So the Arbitration Conciliation Act can be applied, or its rules and processes can be applied to different disputes as well.
And different forums.
Forums as well. Yeah.
Karthik, thank you so much. Happy you found it useful and insightful. Looking forward to take up the course. Thanks a lot. We'll be happy to see you there. Yeah, I think Preeti's number is there. Sorry, Gokul, go ahead.
I said I think we've had questions from everyone. Like we've said, we're all contactable over various social media platforms. You can interact with us. You know where to find us. It's not a mystery or a difficult task to find us. Dr. Bharat and Aditya are a lot more prompt in responding. If you're going to write into me, please bear with my slow pace of responding, primarily because I get about 200 questions a day. And therefore, the mind-numbing task of responding to it. I'm like the Indian legal system, litigation system, wherein every time I finish, there is also already a large number of questions that have already come up. So just be patient, but please get in touch with us if you have any questions or queries about arbitration, about mediation. We would be extremely happy to interact with you.
So the reason Gokul has so many questions to answer is because he actually proactively teaches. It's not like he's randomly fielding questions as well. So he teaches a bunch of the cyber law course and the other courses. He's a very active teacher. So he gets a lot of questions from students who are in his courses right now.
Yeah.
Right? But don't worry, there are people who will respond to your questions. And I've given my email as well in the chat box. And yeah, I'm very prompt. Don't worry about it. Okay.
Yeah, I agree that Gokul is actually prompt. So there's nothing to worry. He's just being very modest.
Yeah. Shashi has a question. So we have a new question. Yeah, Gokul is really modest. If in any agreement there is an arbitration clause, but one party initiates a legal action by sending a legal notice, whether the second party has a right to refuse any further arbitration offer from the first party, from Shashikant. Dr. Nen?
If the party sends a legal notice, all that you got to do to reply to the legal notice is to say that there is an arbitration clause and attach a copy of the clause that ends the matter. If the party approaches a court for any action, you have to apply to the court and say, this is the original copy of the arbitration agreement, there's an arbitration clause, and the court will send it back. But if the second party does not do that and responds to the legal steps, then it is considered a waiver of the arbitration. And then the matter goes on. So be very careful. At the first step, please put forth your objection with a copy of the arbitration clause, and the matter ends there.
Right. Okay. Hope that answered the question to an extent.
I think we finished all the questions from what I can see.
Yeah, we have.
All right.
Yeah. So thank you again, everyone from, of course, all of us from ASCL and us here, Dr. Nen and I and Jonathan as well. We really appreciate you took the time to spend this 1.5 hours with us.